Welcome back, everyone, to Mishnah in Depth, Sanhedrin and Makkot with Rabbi Matthew Nitzanim. For this class, we will be moving from Sanhedrin to Makkot as we continue to move through Daf Yomi with this series. Mishnah in Depth is part of the Rifka Rosenwein Mishnah Division and is sponsored by her family in her memory. It's been excellent to be following the Mishnah Yomit schedule with Rabbi Nitzanim, who is a teacher at Midrashet Amodim and a musmach of the Israeli Chief Rabbinate, as well as holding several degrees from various Israeli and American institutions. We have been learning together over these past few weeks, and this class is assuming that we are following the Mishnah Yomit schedule independently, and we're coming together to review the material from the previous week together. Sources will be pulled up on screen once Rabbi Nitzanim gets underway. And with that, let's get things started finally.
All right. Hello, everybody. Good evening from where I am here in Jerusalem, and it's a pleasure to be with you once again. Thank you for bearing with us with the technical difficulties, and here we go, up to the hour to enjoy this transition from Masechet Sanhedrin to Masechet Makkot, which really, you should know, is a lie. The Rambam, in his commentary to the Mishnah, the Hakdama, he argues that Masechet Sanhedrin and Masechet Makkot are not actually two different Masechtot. They originally were written as a single Masechet, and only later on by later editing teams got split up into two separate volumes or tractates. It's not abundantly clear that that's the case. The manuscript evidence seemed to suggest that they've always been treated as two different volumes. That said, there is a flow that continues, right? We started with Masechet Sanhedrin, these issues around what kinds of courts we have, and then judicial proceeding around witnesses that we accept, judges that we accept, and then going through the various punishments that the Beit Din can execute, namely the various forms of execution. That's what we made through in Sanhedrin. And Makkot, we then shift to Elohen Agulin, Elohen Alukin, those who receive the non-execution punishments, being sent off to a city of refuge, lashes, and so on. So, in some ways, Makkot really continues on with Masechet Sanhedrin, and so it's fitting that we are continuing that learning together. So I'm going to pull up these slides, and let's explore some of these really interesting issues that emerge at the end of Sanhedrin, the beginning of Makkot. If you would be so kind as to give me that thumbs up if you can see the slides on your screen. Amazing. We are ready to go. Oops. Here we go. So just to review the issues, we'll be looking at three topics today, as we usually do. Looking at the end of Sanhedrin, hopefully you saw this week, chapter 11 of Masechet Sanhedrin, the end of 10 and all of 11. I want to talk about familial harm and questions around kidnapping, which, as we'll see, tie into questions around custody. I want to talk a little bit about Zakin Mamre. We won't explore all that is involved in the case of the Zakin Mamre, the judge on the Sanhedrin who challenges the consensus of the Sanhedrin. But there's one piece in particular that I want to revisit in light of something we saw in our first shiur together, and then we'll start off with Makkot and see how our sages argue with the Sadducees. So with that, let's get started. One of the Mishnah that we saw, the very first Mishnah of the 11th chapter, the 11th parak, reads as follows. So in discussing those who are subject to execution, we address the case of kidnapping. Now, the way that we know that one who kidnaps, one who steals a person is chayav mita, subject to execution, is based on the Ten Commandments. Right? If we open up the Ten Commandments, your set of two tablets, we'll see that we have three prohibitions that go hand in hand, that are all brief. Lo tirtzach, lo tin'af, lo tignov. Lo tirtzach is the prohibition on murder, lo tin'af is prohibition on adultery, and then lo tignov, lignov literally means to steal. But the rabbis presume that the Aseret HaDibrot, the Ten Commandments, the Decalogue, must be high-stakes laws, in particular prohibitions. And so it can't be that up there with murder, we're putting theft. And say the rabbis, it must be that the case of theft that is addressed in the Aseret HaDibrot must be one that is akin to murder and adultery in its degree of severity, namely the kind of theft for which one would be subject to execution. The same way that one who commits murder is subject to execution, one who commits adultery subject to execution within the system of the Sanhedrin, so too one who performs a particular kind of stealing is subject to execution. And so the rabbis say it must be that this case of stealing for which one would be subject to execution is kidnapping. And that's how kidnapping ends up on our list. Okay, so back to our Mishnah. Hagonim nefesh Israel. So what does one need to do in order to be treated as one who has kidnapped halachically? You need to take the person into your own domain. Right? Just holding hands to that, holding on to them doesn't count. They need to be in your own domain. Rabbi Yehuda Omer, in order to be subject to punishment, one needs to make use of said person. Shne'emar, this is a language that is used in the Torah, in Sefer Devarim, v'itamer bo u'mecharo. So there has to be some sort of, not only the taking of a person, but also the making use of said person. Okay, so far we've established some of the technicalities, or some sort of definition of what constitutes kidnapping. And then comes a tricky case. I suppose this is the kind of shiur that calls for something of a trigger word in which we're talking about, again, familial harm. What happens when wrongdoing happens in the context of the family. And here we're talking about the taking of children. We have to address the reality of children being taken within their own family. And hence the final line of the Mishnah here, Hagonevet bino, what happens if one takes one's own child? And it becomes a machloket. Rabbi Yishmael benosh Rabbi Yochanan ben Beroka mechayev v'chachamim poterim. So we have a machloket between Rabbi Yishmael benosh Rabbi Yochanan ben Beroka and the sages, the chachamim, whether one is subject to punishment in the case of kidnapping one's own child. Now, it's worth noting that this is the kind of case that we should be concerned about. Rabbi Yerucham Fishel Perla, an unbelievable scholar who's really known for his one magnum opus, his commentary on Sefer HaMitzvot of the Rasag of Rav Saadia Gaon. Rav Saadia Gaon, prior to Maimonides, prior to Nachmanides, and some of the other folks in the middle period who did so, Rav Saadia Gaon in the, I want to say, 9th century or 900s, one or the other, comes up with a list of the 613 mitzvot. Well, not exactly 613, but he comes up with a list of the mitzvot in the Torah. It becomes a medieval project. Quite a number of medieval scholars get caught up in this project. The Rambam is probably best known for it, but all these medieval scholars try to figure out, we know there's a bunch of mitzvot, wouldn't it be nice if we had a list? And Rav Saadia Gaon is one of the first to come up with such a list. But it's not a book that he writes, it's just a poem, a piyut, which seemingly was meant to be recited on the holiday of Shavuot, and still is recited in some communities. So it's a poem that lists the mitzvot of the Torah, and
Isn't that Ibn Gabirol?
Ibn Gabirol also writes a piyut, which is more popularly recited in community of Eidat Mizrach on Shavuot, that goes through this sub-genre of piyutim. It's called Azharot.
Because I know I do it.
Come again?
Yes, I do it in my community.
Oh, unbelievable. So the Azharot of Rabbi Shimon ben Ibn Gabirol are more commonly recited, especially in Syrian communities, but we know that Rav Saadia Gaon also had a version of Azharot. Why am I telling you all this? Rabbi Yerucham Fishel Perla, the 20th century scholar, has this idea to write a commentary on the Sefer Mitzvot of Rav Saadia Gaon. But again, what Rav Saadia Gaon wrote was a poem, and what Rabbi Yerucham Fishel Perla wrote was a 3-volume commentary on this one poem, trying to work out the intricacies of what does or doesn't count as a mitzvah. It's an unbelievable work of scholarship. And why I mention it is because he has a number of really crafty claims that come up in the Sefer. He addresses the case of kidnapping and argues that the reason why kidnapping falls under the term gneva rather than gizela as a general rule, right? Both lignov and ligzol refer to stealing, but he claims that in rabbinic language, gneva generally refers to the kinds of stealing that go unnoticed, that are done sort of more secretively than gzela, which is sort of like shoplifting, just walk in and take stuff. And it says we presume that most cases of kidnapping, especially if they're happening within the family, are happening without a lot of people noticing. And that's why we use this term gonev rather than gozel. It says even though the Mishnah presents it as there's this case called kidnapping, and then there's this sub case that emerges, what happens if it happens in the family, says we should presume that most cases of kidnapping tend to be issues that have to do with family tension, familial tension. And depending on how we define kidnapping, he may well be right, even today. These are the kinds of cases where we run into problems around claims to children when familial harm arises. Okay, so with that in mind, what I want to do is sort of unpack this case from the vantage point of contemporary issues around custody. Right, the Mishnah has made clear there is a prohibition from the Torah, arguably one of the 10 Commandments, on kidnapping, on taking a child or any person, but we'll refer particularly to children, taking a person against their will into your domain. And the Mishnah also mentions that arguably the same is true even in taking one's own child, which is a puzzle. Excuse me, it's a puzzle. What does it even mean to take one's own child? Today, earlier in the afternoon, I went to the Gan, the nursery not far from my house, and I picked up my child from the Gan. That isn't criminal, I don't think. That's exactly what I'm supposed to do. I took my child home. It can't be that any scenario of taking one's own child home is into gnevat nefashot, but yet there is some sort of case in which that can happen. And the question is, how does halachic category get applied in later halachic writing? So I want to focus on some halachic writing really from the past century, even I suppose even more recent, the past few decades, that address issues around gnevat nefashot. So we can start with the tshuva of the Mishnah Halachot. I realized as I was opening up the slides that I didn't catch the year, but the Mishnah Halachot lives in the 20th century. I presume he's writing. I'm gonna say this tshuva is maybe in the 70s, if I had to guess. The Mishnah Halachot of Rav Menashe Klein comes from the Hasidic tradition of Ungvar. And yet was a prolific halachic writer and had real influence in his halachic writing on Hasidic communities, in particular in the United States as well as elsewhere. And he was asked about what happens when the authorities, the government authorities, want to take a child into government protection, right, to child protective services. If there's some concern about the safety of the child. And he writes the following. It might be a little bit hard to read. I want to hear it for what it is, and we'll unpack it together. He writes as follows. Vihine, vihilakacha yeladim mehahorim, osim kan kamaraot. When a child is taken from their parents, multiple wrongdoings have been done. Achat, first of all, shelokhin et hayeladim mitachat yad aviv v'imo v'hu isur Torah ligzol me'adam banav. First of all, there is a prohibition in the Torah of taking a child from where they're meant to be, and presumably where they're meant to be is at home. So in taking that child, you've committed the prohibition on kidnapping. Vagoniv nefesh adam chayav mita. And doing so, it makes one eligible for execution. V'kol shekin gazlan shechamur meganav. And all the more so in a case like this, where he's imagining where a child is being taken by child protective services, it's not being done secretively, namely gneva, but quite publicly and openly, what we would call gzela. Right? The Torah doesn't even address the case of gzelat nefashot, only addresses gnevat nefashot, on the presumption that no one would, out in the open, take a person, especially a child, from where they belong. So this would seemingly be an unbelievable abrogation of Torah law. I'll continue. And furthermore, even an animal suffers when his children are taken from it. We have prohibitions that are stated in the Torah that are meant to reduce the pain, the suffering that an animal would feel if its child originally taken from it. He mentions the prohibition of taking away a child within 7 days of its birth from its mother. There's also the prohibition of taking away eggs or chicks if the mother bird is present, when it's called shiluach haken. Right, so the Torah cares a great deal about the right of parents to be with their children, or the pain that parents would experience if their children were taken from them. The kol shekain av, all the more so father, he says, that according to some views, loves his child more than himself. He gets this, for the record, this notion that appears in here and there in halachic writing, that parents, especially fathers, care for their children more than themselves. Where might we get that from? What precedent might we have to suggest that there'd be nothing worse for a parent than their child being taken from them?
Yaakov,
okay, creative, right, where Yaakov suffers immeasurably when Yosef is taken from him. I believe that the reference is to a claim made by Rabbi Yosef Albo that the Akedah, the binding of Isaac, was the ultimate test. Says Rabbi Yosef Albo, the ultimate test, the ultimate nisayon would have been if Avram had to give up his own life. So why was the ultimate test to give up his child's life? Says Rabbi Yosef Albo, it is because that was an even greater test, for that would be an even greater sacrifice. And so, bringing it back to the Mishnah, said there can be nothing worse than that to have one's child taken away. There is no greater evil, no greater violence that could be done than taking a child from its parents, even in addition to the fact that it is a Torah prohibition. Okay, so Rav Menashe Klein is arguing, I think, reasonably within halach, in terms of the halachic material, that it's hard to justify taking a child from one's parents. That seems to be the definition of what constitutes gnevat nefashot. His case, though, is a tricky one. He's talking about a case where there's some nervousness about a child being subject to harm and Child Protective Services taking that child. And he is arguing that even there's a concern of gnevat nefashot. That's, at least on my own ears, a hard claim to swallow. If we were to read further in the Tshuva, he also has, there's some difficult language there about his presumptions about what constitutes harm to children, and maybe does CPS even understand what's happening in these families, and all the children are fine, and they don't understand. Okay, there might be something sociocultural happening that we're missing in the story, but there's something a little bit hard to hear in his writing. But his point is still an important one to hear halachically, and yet I don't want us to lose sight of what we saw in the Mishnah. The Mishnah notes, as we saw, that it is possible to commit kidnapping vis-a-vis one's own child, hagonevet beno, which means, halachically, that it need not be the case that the right place for a child to be is with their parents. Right? That might be our default, that that's where a child belongs. But if it is possible for a parent to kidnap a child, then it must be that it is not necessarily the case that with one's parents is the right place for that child to be. And so it would be interesting to have a conversation with Klein, if he were still with us, to imagine what might be the implication of our Mishnah for whether it is necessarily the case that having a child with their parents is not kidnapping, and that taking a child from their parents is kidnapping, if it's not what's necessarily in the best interest of that child. You should know it is certainly the case that in the state of Israel, the system that takes care of children, the term is not Child Protective Services, but has the same function. There are all sorts of scenarios that arise. Generally, the Bati Din don't really have authority over such cases, so everything that we're discussing here is really theoretical in terms of the halacha, but it raises important questions for us to think about at a societal level, where these questions do actually have some bearing on rabbinic discussion and practice. is a different kind of case that has to do with custody. Now, before we talk about contemporary custody battles and whether Gnivat Nefashot applies there, I want to start with a Maharashtam. Maharashtam is writes his tshuva in the 1600s, and he has his tshuva about a custody battle, which has become, since then, a key source in discussing the halachot of custody determination in Batei Din, even to this day. Today, there are, in a sense, no Batei Din with independent custody jurisdiction. In the United States, the Batei Din generally do not handle custody issues. One has the right to, when signing a halachic prenup, assign the Beth Din of America the authority to navigate custody issues. Though I once spoke with a Dayan who said, I strongly encourage you not to sign that piece of the prenup. At the end of the day, the state authorities are probably better positioned to navigate these sorts of issues. So it's quite rare in the US that the Batei Din handle custody. In the state of Israel, it's more complicated. And that's because, in theory, all issues related to divorce can be handled either in the civil courts or in the Batei Din. It's a question of which jurisdiction gets the case first. This is really sort of a mess of a legal reality in Israel where either party can open up a file, and whichever file opens first, whether it's in the civil court or the Beit Din, that determines where the case is handled. And so in theory, it is possible for Batei Din to navigate custody issues, though oftentimes it anyway ends up in civil court. That's all to say, most of what we're discussing now isn't exactly halachic in terms of how it gets played out today, and yet there are halachic cases that have arisen, and so it's worth thinking about that. And in that context, the Maharashtam is an important source addressing a case that really was handled by the Beit Din in the 1600s. And what he's dealing with is a scenario where it's hard, he describes the case, it's hard to know if he's giving us an objective account of what's happening, and he doesn't give us so many details, but there's some scenario where a couple is married, there's a child, and the mother decides that she's moving to a faraway place and taking the child along. And the question is, does she have the authority to do that? And the Maharashtam writes as follows: V'im tumar, u'menale deben eino yachol lotzio ha'im l'makom shehi tirtzeh. So if, he says the Maharashtam, if you ask me, well, what evidence is there halachically to say that the mother does not have the authority to take the child to whatever place that she chooses? Ha'avodah shenir ali shemi shefakpek bazeh eino ela min hamatmihin. If you question the oddity, absurdity of a parent being able to just take their child to a faraway place, then you are the one who is min hamatmihin. You're the one who's sort of off your rocker. Can it be that a child would have this, in this scenario, one child who is beloved to them? The heart is, the father's heart is tied up with the son's heart. This, per Andrew, is a reference to Yaakov's relationship to Binyamin. And the father would suffer tremendously at the prospect of being separated from his child. And yet, nonetheless, that the mother would have the authority to take the child to a faraway place. In hadat sovel bezvara. It's unimaginable that would be the case. I don't even need evidence, says the Maharashtam, to prove to you that it can't be that one parent can just take a child, pick him up, and bring them to some other place. It can't be. That's a bold claim, maybe reasonable, but bold. But he says it's just so obvious to us in our conception of family that I don't even need to bring you real evidence from traditional Torah or halachic sources. What's interesting about Maharashtam is that he fails to bring a halachic source. He says the way that we know that you can't take a child away from, that one parent can't take a child away from the other parent is because it's just so obvious. He kind of borrows some language from the story of Jacob and Joseph, but he doesn't really bring a source, even though what would have been the sort of go-to technical halachic source to say that you can't take your child away Right, well,
Sorry.
we're discussing the prohibition on kidnapping, right? Genevat
This
nefashot.
Mishnah.
Yeah, fantastic. Our Mishnah that says there's a prohibition on genevat nefashot, and it is possible to kidnap one's own child. It's not so clear what that means, but arguably, what that could mean is there are two parents, and one parent takes the child away from the other one. That's a case in the Mishnah. That would be an isur deoraita in the Aseret Dibrot, and yet the Marash Dam doesn't cite the case, the rule of genevat nefashot. It is a lengthy tshuva and arguing that this mother can't take the child away from the father. And that's very telling, that it seems so easy to lean into genevat nefashot, and yet he fails to do so, which might suggest to us that he doesn't think that it really counts as genevat nefashot. Maybe because, per our Mishnah, if you're simply taking a child, but you're taking care of them, you're not turning them into slave labor, something like that, right? The vehit amirbo, that doesn't count as genevat nefashot. Maybe if you were a parent and you think that the very fact that you're protecting your child, it doesn't fall into genevat nefashot. It's hard to know why he doesn't adopt genevat nefashot as his framing, as his anchor, but he doesn't. And that would suggest to us that maybe genevat nefashot can't be the right category to use in thinking about a custody battle between two parents. Why this matters is because there's an organization here in Israel called Horut Mishutefet, Shared Parenting, which argues really strongly for custody arrangements in which both parents maintain claim to children. They kind of politically, as best as I understand, are sort of in the what we end up calling men's rights camp, right? They argue for shared parenting. What they're really trying to push for is that a father should not be cut off from custody, which is what is more likely to happen oftentimes in custody battles. And they they publish this sort of tshuva, sort of a halachic position paper about why it's important that, from a halachic vantage point, right, if the court or a beit din were to be dealing with a custody issue, why they should push for shared custody between the two parents. And just one passage writes as follows in the yellow. It's a summary of what's been stated in the tshuva. Hahorim v'ha'av bichlalam, the parents, including the father. So there's really a concern for the protection of the father here, father's rights. Einam chefetz domem lelo regashot retzonot v'ga'aguim. They're not just objects that have no feelings. Ve'inam rak mishartei tovat hayelad. They're not just here to serve whatever is best for the child. Ela chova litzchashev bahem u'v'rigshotehem. We have to take seriously both of the parents' feelings themselves. And this itself is part of the obligation of honoring one's parents, to take the feelings and concerns of the parents seriously. And similarly, and this too is an obligation upon the beit din, meaning the argument is parents all have feelings towards their children, and that needs to be taken seriously by the beit din in determining who gets custody. Who does that sound like? The Maharash Dam, right? And they cite the Maharash Dam, I think, 6 times in this tshuva, right? We have to take these feelings of the parents seriously, just intuitively. And then there's another line at the end. V'archakat ha'av miyeladav, to separate a father, or otherwise a parent, from their children, alula la'alot ad kidei ha'isur ha'chamor shel gnevat nefashot. It might even reach the level of kidnapping. Meaning, if there's a custody battle and the court or the beit din rules to leave the child with one parent and not to give access to the other parent, that might constitute gnevat nefashot, halachic kidnapping, kavish and avila kavan, as we will explain later. So they argue, this organization, or Mishutefet, shared parenting, that it counts as kidnapping if the beit din or the court rules to give custody only to one parent, or full custody to one parent. Now here's the interesting thing. If we read through the whole tshuva from this organization, from shared parenting, they cite the Maharash Dam a bunch of times, and they also mention in passing Rav Menashe Klein. Those are 2 of the key sources that they reference. What's striking is, does either the Maharash Dam or the Rav Menashe Klein, does either one of them claim that assigning the authority of parenting to only one parent and separating from the other, does either of them claim that that is halachic kidnapping? No. The Marashdam says it would be a horrible thing to separate a child from one of its parents, but fails to say that it constitutes kidnapping. And Rav Menashe Klein claims that to separate a child from both of its parents to hand it over to CPS, to Child Protective Services, that would be kidnapping. But neither one of them says that in a custody battle, giving full custody to one parent to the exclusion of the other constitutes kidnapping. And yet, Hort Mishutefet takes these two things together, takes Rav Menashe Klein, moving kids around counts as kidnapping. Marashdam, you ought not halachically separate a parent from their children, puts it together and says, giving full custody to one parent is halachic kidnapping. Yet neither of the sources they cite brings us to that conclusion. What are we going to do with all this? I'm not a dayan. I don't think anyone here is either. But I just want to sort of alert us to the fact that some of these cases that seem sort of far off, the taking of children that appear in the Mishnah, actually have, well, they might have bearing on halachic discourse even today for real contemporary issues that have to do with familial harm. And yet, we need to make sure that we're studying these cases really, really carefully to make sure that we're not abusing halachic precedent or halachic sources to get to conclusions that might not actually be as well grounded as they seem. At the end of the day, the Mishnah told us, Hagonevet beno, there is such a case of kidnapping with one's own children, though it's not exactly clear how we define that. There's what to flesh out in the Mishnah of what constitutes Gnevat Nefashot, and it's not clear how exactly that should get played out, which leads to the machlokot that emerge even today. I'm not here to reach a firm conclusion about how we ought to think halachically about custody, about child protective services. I'm not in a position to do that. And it's a good question if that's even the right. Doesn't even make sense to think about that in strictly halachic terms, divorced from the particular civil jurisdiction in which we find ourselves. But it's worth contending with what the Torah, what our tradition has to say about these sorts of issues. I'll pause only to say that we're at this particular juncture in this Jewish moment, in our Jewish present, where the separation of children from their parents is unbelievably present, and hopefully for at least many people coming to an end. Though we can only hope that our study of Torah should be for zechut, for many, many families, those who are especially on our mind, and wherever else they might be, that we should have restoration, wholeness, healing for all those who need it. And with that, I want to briefly address the Zaken memory. Actually, I'm sorry, I'll pause. If there are any last questions, comments, concerns about this case. Saul.
Yes. As I was listening to you, and you mentioned the Akedah, it strikes me there's another way of looking at that, in the sense that Abraham took Sarah's child, and that's usually not talked about, except in that Sarah dies shortly afterwards.
Mm-hmm.
But it seems to me that that's a very good but negative example of the kinds of issues that you allude to, because you can make the argument God told him, but that doesn't change Sarah's relationship to Yitzchak. So it seems to me almost from the beginning, the Torah doesn't make a clear answer of what you should do or shouldn't do.
So thank you for mentioning it, Saul. I 2 points about the Akedah. And yeah, when we're thinking about, I spent some time when working my master's degree, which was in bioethics, on issues around philosophy of the family. That's what they refer to the subfield these days. How do we think ethically about familial relationships? How do they work? What do they ask of us? What do they allow from us? And so on. And yeah, there's a lot to piece through. even generally on applied ethics, and also within the framework of the Torah. What is the Torah's account of the rights of parents, the obligations of parents, and so on? The Akedah is really interesting for two reasons. One, Akedah is it's such a rich story in the sense that it has so many interpretive layers, thanks to our inherited tradition in the Midrash and medieval commentary and artwork. There's a lot to work with there. And so what's really striking is that both in some of the Midrashic tellings of the Akedah, as well as in some of the liturgical poetry, the piyutim, that have been written about the Akedah, in particular for Rosh Hashanah, there's this engaging with what is the role of Sarah Imenu in the story? Where does she fit in as a character? Because in the text itself, she's just not there. She's just, when the story's over, we hear about her death, but it's not clear that's part of the story. And yet there are some voices in our tradition that try to engage with that question and really ask exactly what you're saying, Saul. At what point do we say Avram has done a wrong towards Sarah and having taken the child, arguably without her permission? Now the Midrash fixes this, some of the Piyutim fix this by crafting a version of the story in which Avram consults with Sarah and gets her okay first. In some versions, Sarah's like, go for it. In some versions, Sarah's actually kind of hesitant about it. There's also a different version in which Sarah dies because she is so shocked to find out about what happened, right? In which case, maybe there was a wrong that's done there. That's all just to say, if we're thinking about these questions of the philosophy of the family, it'd be cool to unearth what the Akedah has to offer us, especially you're right, in the Sarah position. Also to mention one other point, which is a really unusual machloket between the Maratz Chayes and the Khatam Sofer. Maratz Chayes and the Khatam Sofer, both of the 1800s, both do extensive halachic writing. The Maratz Chayes also, as a teacher of mine once said, the only PhD who's printed in a standard edition of the Talmud, his glosses on the Talmud are printed in the back, the standard Village House. Excuse me. But he had an academic background. Really interesting positioning in terms of his relationship with Haskalah and so on. Maratz Chayes writes that, where he asks the same question everyone asks, how could the Akedah be okay? How could it be justified to sacrifice one's own child? And Maratz Chayes argues that if we look through Tanakh, he says there's plenty of evidence to suggest that from the vantage point of the Torah, the standard presumption was that parents own their children. Children are the property of their parents. And therefore, it's kind of the right of Avram to kill his child. It's not very nice. It might be a hard thing to do to make him sad, but it isn't technically unethical because his child belongs to him. His child is his property. He brings up evidence for a number of places in the Torah that might point in that direction. The Khatam Sofer is incensed at the suggestion that the Torah is okay, that believes that you just own your children, and pushes back. But it was a machlok. They had a letter exchange between them. We have this letter exchange. I mention this because Rav Yuval Sherlow, who's a rabbi thinker based here in Israel, has done a lot of work in medical ethics, never says that the Maratz Chayes is sufficient evidence, but he puts it in a few footnotes in his writing here and there that it might be the case that if we were looking for evidence for the notion that parents have the authority to agree to medical treatment for their children, that it might be that if the Torah thinks that parents own their children, we could use this as a basis for allowing parents to agree to medical treatment. Why have I told you this whole story? Only to say that these questions of these narratives in the Torah about parents and children and what they can and can't do, they might offer us some insight for how I think about contemporary ethical issues, or they might not. And that's sort of an open question that is still open to debate. So I'm grateful that you mentioned the case of the Akedah. Sandra.
I put it in the chat. I believe that none of these sources are taking into consideration abusive parents, abusive parenting, and they're talking about, especially the custody issues in today's world. They're talking about cases where you have a reasonable mother, a reasonable father, they get divorced, and now they're using the kids to fight against each other, which is obviously wrong for the child, and etc. but none of the sources, and probably because in those days this concept of abuse did not exist, right, discuss what happens if you have a parent, one or both, who are either drug addicts or alcoholic or just emotionally completely inept to be close to the child and if are harmful to the child. I imagine that there are rabbis writing response about this, or no? Or do we still pretend it doesn't happen in the Jewish world?
There isn't so much halachic writing, in large part because there aren't so many halachic cases that arise, because in the majority of cases where there is demonstrated evidence of abuse in the home, of domestic abuse, then it's anyway being handled by civil authorities, and no one's asking the rabbis what they think about it, right? There are very few cases where Batei Din are handling a case where there is demonstrated abuse involved. So there isn't much to offer, but again, not necessarily because rabbis oppose it, they just didn't have the opportunity to say one way or the other. Rabbi Menashe Klein is surprising in that he's very hesitant about what he sees as America's approach to abusive parenting. But there are other halachic writers who are much clearer about the fact that it is definitely the case that it would not constitute gneivat nefashot if you are protecting a child. Yeah, that definitely exists. I want to highlight the sources that suggest that the category of gneivat nefashot is relevant in this story, but yes, there are definitely voices that would argue otherwise. Okay, in the time that we have left, I think with this we'll sort of call it a wrap on Sanhedrin, and I want to at least have started the study of Makkot together and discuss at least one issue that arose in Masechet Makkot. So if you'll bear with me for a moment, we'll get the slides back up here. All right, so as the slides are coming up, what I want to address is in the first chapter of Makkot, right with Sanhedrin behind us, Makkot opens with the discussion of witnesses in a different vein from how we saw witnesses in the third chapter of Sanhedrin, right? As a reminder, what have we covered about witnesses way back in the third chapter of Sanhedrin? You can shout it out. Okay, so what we covered
different types of death.
What? Say that again.
Different types of ways of killing people.
Oh well, we've addressed the different ways of killing various folks. How
you vet them, how you
excuse me. Yes, exactly.
Interrogate them.
Exactly. Thank you, Ava. What we established about witnesses is that there are certain people who are disqualified from testifying. What we have not addressed is so far, right, in Masechet Sanhedrin, is this particular case of what happens when the witnesses lie. Meaning, we do know that witnesses lie. That happens. And because we have the mishnayot in chapter 4, where we remind the witnesses not to lie. We forewarn them against lying. And here we have in Masechet Makkot, what happens if the witnesses do in fact tell a lie? With that, here we go. I think we have this going. That's not it. Done. We're gonna click slideshow. Just give me that thumbs up if you can see the slides.
Yep.
Fantastic. All right, we're sliding through, and here we are. And we're gonna argue with our friends, the Sadducees. Let's rewind for a moment. Some Jewish history. We're in the Second Temple period, and we've got this group called the Sadducees. There's a lot to unpack about the Sadducees, but what is of particular interest to how the Chachamim experience the Sadducees, or maybe imagine the Sadducees, hard to know for sure. Let's do Kim, is that they tend to take a fairly literalist approach to the interpretation of the Torah. Now, no one's really anyone engaging with the text of the Torah needs to do some degree of interpreting, but they tend to take a more literalist approach. They are different from the Karaites, the Karaim, though they are in many ways the intellectual antecedents to the Karaites, a movement that similarly takes a fairly literalist approach to the reading of the Torah, in contradistinction to the rabbinic tradition, what is sometimes called the Pharisaic tradition, that is more creative in its interpretive license. There are still Karaites around today, not too many of them, but it seems like the rabbinic project has really won the day. But here we still have some reflection on argumentation with the Tzedukim, with the Sadducees. And we have this Mishnah that we saw this week. Reads as follows. Okay, so if we have a case of Eidim Zomamin, namely framing witnesses who frame some person for having committed a crime, when in fact the person did not really do so, as is proven by additional witnesses proving that the framing witnesses couldn't have been, excuse me, in the place where they claim to have been to have witnessed the crime. So if this happens, then the framing witnesses can be killed, depending on the circumstances. Again, it can't happen ad shegamer hadin. That only happens once the ruling has been completed. Sharetz dukin omrim. This is in contradiction to that which the Tzedukim, the Sadducees, claim, which is ad sheyahareg, that Eidim Zomamin, framing witnesses, are only executed if the person whom they framed also got executed. I mean, not only did they frame someone, but it went through the court and that person got executed, then the Eidim Zomamin can be executed. That's the way that Tzedukim read it. The Chachamim, right, our sages of the rabbinic tradition, say no, even if the witnesses come, they frame someone, and there's a rule that the person needs to be executed, and then we find out that the person was framed, we already have justification for executing those witnesses. Okay, so we have this the Mishnah presents the claim of Tzedukim. Amru lahem chachamim v'alo kvar ne'amar v'asitem lo kasher zaman lasot la'achiv v'ari achiv kayam. So the chachamim, the sages, argue that it says in the Torah that you shall do to a framing witness v'asitem lo kasher zamam, as they framed or intended, la'asot le'achiv, to do to their brethren, to this person. So the Chachamim say that it's clear from this verse that the person whom they framed is still around. Because the verse suggests that you do to them what they want to do to him. So he's there. Okay, not the most compelling read of the pasuk I could have come up with, but so say the sages. Now, why does this matter that the sages and the Tzedukim have this argument? What's striking is that it's right, we don't have the Sadducees presenting their own argument. We only have the rabbinic presentation of the Sadducees' argument. But what's striking is that we might be familiar with another case where the Tzedukim read this same verse, nefesh tachat nefesh. Right? This is a verse from Sefer Shmot, from the book of Exodus, where we're talking about what happens if damage is done to a person. Actually, there's a question about damage to a fetus in particular, but then it's expanded to other people, and says as follows: if damage is done, nefesh tachat nefesh, give life for life, ayin tachat ayin, eye for an eye, shein tachat shein, tooth for tooth, yad tachat yad, regel tachat regel, hand for hand, foot for foot. Now, what does eye for an eye seem to mean? It seems to mean an eye.
Tit for tat.
It seems to be an eye for an eye, right? If I damaged your eye, you damaged my eye. That's how I reach parity.
No.
That's what. No.
Well, it may seem, but I don't think it is. It is what you have to pay for, right?
Okay, I love what you said. It seems like that's what it's saying, but I don't think it's what it is. Amazing. The rabbis felt the same way. He said, maybe it's what the verse sounds like, but it couldn't possibly be that's what really the Torah is asking of us, which is why the rabbinic tradition reads nefesh tachat nefesh and ayin tachat ayin, this verse, as payment for the damage that's done. Payment that is equivalent to the damage that's done. Now, that's not the straightforward reading of this verse, but it seems, for whatever reason, the rabbi, may arguably ethical, though we don't know for sure, the rabbi say it must be there's something else going on here, that we're talking about payment. But there are folks who said that it should be read literally. Those are the Sadducees, right? The Sadducees take a literalist approach to reading the Torah, and they interpret this as, no, really, life for life, eye for eye, tooth for tooth, and so on. And so it's striking that when the rabbis are imagining how the Tzedukim would relate to the case of Eidim Zomamin, what shows up in our Mishnah, they bring them back to this verse, nefesh tachat nefesh, life for life. Meaning they keep sticking the Tzedukim into this literal reading of this particular verse, nefesh tachat nefesh, even though the rabbis themselves repeatedly adopt a non-literal read of this verse. It's as though they're trying to highlight how uncomfortable they are with what would happen if we adopted a literist reading of the Torah, meaning there are other verses that come up, but this one in particular really is uncomfortable, and how they're going to go out of their way to interpret against the grain. And so I just wanted to appreciate that what our Mishnah does in setting up the Tzdukim and the Chachamim against each other is coming to highlight an argument that is resting upon another argument with the Tzdukim about general punishment, not only specifically the case of framing witnesses, edim zomimim, but in general, that we have this, we know that the sages and the Sadducees argue about what happens when damage is done to another person more generally, again from this verse, nefesh tachat nefesh. Now, why this matters to us, I think, is because of the continuation of the Mishnah, and with this we'll be able to finish. The Mishnah similarly points out that there are these rules about how many witnesses need to be together in order to apply to them the rules of framing of edim zomimim, and it takes this verse api shnayim edim o shlosha edim yumat hamit, that on the basis of 2 or 3 witnesses, we're told by the Torah, one can be sent for execution. And the Mishnah tells us that the fact that Torah says 2 or 3 indicates that 2 and 3 go hand in hand, namely that whatever number of witnesses you have, the entirety of the group, whether that be 2 or 3 or even 100, they all need to be part of the framing scheme. Why do I mention this? The Ibn Ezra, in his commentary on this verse in the Torah, has a striking claim. Why does the Torah say that on the basis of 2 or 3 witnesses, someone is sent to execution? It can't be that the minimum number, the minimum threshold of witnesses that you need is either 2 or 3. That's not a minimum. How do we get these 2 or 3 business? And says the Ibn Ezra in his final line, in his commentary there, when he tries to work out the different ways we could interpret what it means 2 or 3, V'gam anachnu tzrichim ba'al korchenu l'divrei HaKabbalah. Says Ibn Ezra, this verse is proof that we need to have some sort of inherited rabbinic interpretive tradition. There must be what we'll call the Torah She'ba'al Peh, because it can't be that the Torah can just be read literally on its own at face value, and that would tell us what to do. In both this Mishnah, which is Mishnah Zayin, and the previous Mishnah, Mishnah Vav, in the argument with the Sadducees, when the rabbis are interpreting these verses around edim, they're a little bit coming to highlight a point. Again, edim, witnesses, Beit Din, is actually the locus of rabbinic authority, the Beit Din. They're going out of their way to interpret these verses in such a way to highlight the fact that we ought not interpret verses literally. We must have an inherited interpretive tradition, we'll call the Divrei Kabbalah, we'll call the Torah She'ba'al Peh, which is part and parcel of how we understand the Torah. And so I think the rabbis are very intentional at a literary level of incorporating into Masechet Makkot, into the discussion of the laws of witnesses, these reflections on how we interpret the verses, the psukim in the Torah, to highlight the fact that we are not stukim, we do not interpret literally, rather we interpret in a lot in the ways of the rabbis, right? In consonance with the rabbinic tradition, for the jurisprudential reasons that we've discussed in the past. The rabbis have ethical conclusions they want to get to, and they need to work within the text of the Torah to get there. So perhaps as you were going through the Mishnah this week, hopefully it sheds a little bit of light on a piece of that story. How the Mishnah is working with these ideas and trying to highlight the authority we need to recognize in the rabbinic tradition. I'd love to take questions and comments, but thanks to the late start, we're already over the hour. I'll just mention in passing that next week will be our final shiur together on Masechet Makkot. We're going to be talking about these 2 key issues that show up in chapters 2 and 3 of Masechet Makkot: the Arei Miklat, the cities of refuge, and the rules of Malkot, of lashes. So that's what you should be on the lookout for this coming week in your learning. We'll discuss it together in another week's time. At this point, I'll say we should probably let people go. If people have questions, comments, feel free to be in touch. I think my email, my contact information was sent out to the group. And looking forward, Bezrat Hashem, to joining together next week to finish off our learning together.
All right.
תודה
Thank
רבה.
you, Rabbi. Thank you, Rabbi Nitzanim. And if I missed a question of yours today,
Thank you.
you can always reach out by email. And I look forward to seeing you next week for this final session, and in future sessions when this series continues, not this coming week, but the following week, with Shavuot at 2:15 p.m. Eastern Sundays with Shalhevet Schwartz. And with that, take care, good afternoon, good evening, and best of luck with the learning ahead.